All right, this time I'll get started with our Justice Court Department 9 judicial interviews. Sitting closest to me is Judge Bonaventure, the incumbent. Next to him is Steve, or Stevie as I know, Steve Goldstein, and Robert Kurth. And gentlemen, we have so many, 3 candidates and enough of a panel. Let's try to get a brief introduction, and then what will happen is try to limit your answers to 1 minute. Where we've had other judges here without opponents, we kind of ramble and go on. And so we'll start with the closest to me, Judge Bonaventure. Please go ahead.
Hello, good afternoon, and thank you for your time. Thank you for the opportunity to speak to you all today. My name is Joe Bonaventure. Just to briefly introduce myself, tell a little bit about myself. I was born and raised here in Las Vegas. I attended UNLV. In fact, I never left Las Vegas after UNLV. I was part of the charter class at the Boyd School of Law. I was elected a Justice of the Peace in the Las Vegas Justice Court in 2004. I was re-elected in 2010. I currently serve as a Justice of the Peace. I was selected by my fellow judges as the Chief Judge of the Las Vegas Justice Court in 2013. I currently serve as the Chief Judge of the Las Vegas Justice Court. And this is my community, as I said. I was born and raised here, never left. I love the Las Vegas community, and I consider it a real honor and a privilege to serve as Chief Judge, to serve as a Justice of the Peace, and this is my way of serving the community. So again, thank you for your time.
Good afternoon, everybody. My name is Steve Goldstein. I have been living here in Las Vegas for the last 18 years. I was barred in 1997. I can't believe it's been that long. I spent about 14 years of my career working in the civil litigation arena. Then I switched gears and started to fall in love with the criminal defense work, and that's where it's led me to today. I actually work with one of your panel members there, Mr. Craig Mueller. You can hold your applause for him. But anyway, I've been a mediator, an arbitrator, and I've been in every facet of any kind of litigation you can think of. I've pretty much done. I know the court system in and out. I consider Las Vegas my adoptive home. Like I said, I've been here for 18 years, which is a very big majority of my life. Well, not quite a majority, but it's getting there. I'm thankful to be here. I want to serve as the Justice of Peace, and thank you for your time.
Good afternoon, I'm Robert Kurth. I'm thankful for being here today. I'm thankful for the Veterans in Politics. I'm thankful for all of you taking your time out today. I know it's quite a sacrifice to do that. I grew up here in the Las Vegas Valley. I've been here since I was 3. I'll be married 30 years this year. I have 4 kids. My oldest is a school teacher. My youngest was doing her softball tryouts today over at high school for a fast pitch. One of my daughters is a dental hygienist, and my son is an officer of Metro. I didn't serve in the military, but I have some of my family that did serve in the military, and I'm very proud of that. Cousins, uncles, and grandfathers, and respect everyone that does that, as well as law enforcement. During my practice here, I'm in my 24th year of practicing law. I've handled civil and criminal the entire time. So I've been in the municipal courts, the justice courts, the district courts, and I've been in a lot of them throughout the state of Nevada. I've been licensed here since 1992. I went to law school up in Denver, and when I finished there, I just came back because this is my home. This is the place where I've raised my family, where I care about the community, and I would appreciate being your Justice of the Peace.
Thank you, gentlemen, and we'll get started. Ms. Levy, you look ready to go with that microphone.
Thank you. Just to start, I appear in front of every single Justice of the Peace here, and my name appears on Judge Bonaventure's support list. As such, I'm going to be abstaining from the vote, but my name's on his support list, and this will come as no surprise to either of the opponents because I told them both personally that out of all of the judges, I think that Judge Bonaventure is the absolute best justice court judge. And I am allowed to ask a question, but I will be abstaining from voting, and it will be a softball. Judge Bonaventure, you are the chief judge, and you've been the chief judge now. This is your second year, and you heard the question posed to Judge Saragosa before, and with regard to AB 193, several of your colleagues, after this letter, this neutral letter that went out on March 31st, 2015, which said was a collective opinion of the judges, several of your colleagues wrote letters in strong opposition to AB 193. If you were against AB 193, why didn't you express your opinion? You appear to stay silent or acquiesce to Judge Saragosa's neutral position. And in the future, because we know it only passed in limited scope, if the same or similar bill is proposed again by the district attorney's office where hearsay can be used of the alleged victim in any and all felony and gross misdemeanors, what would be your position at that time?
And Your Honor, before you answer, just all three of you know other judges have answered this question. So the panel is aware is about the hearsay exception, and also that AB 193 was about taking pleas and other things. So we can just jump right into the answer.
Well, first of all, thank you for the compliment to begin your statement. I do appreciate that. As to AB 193, I wasn't present when Judge Saragosa gave her answer, and I know that you're all aware of that, as Judge Angela just stated. As it was first written, it was very broad, included any hearsay, admissibility, and I was against that. And I'm not aware of any judge, any justice of the peace on the Las Vegas Justice Court that was in favor of that. Certainly no one, to my knowledge, supported that whatsoever. Judge Saragosa stated what I believe was an accurate description of what happened at that judge's meeting. In fact, actually, she lowballed the number. There were 13 out of the 14 judges that were present at any point in that meeting. Some did leave before that discussion. I understand the importance of a preliminary hearing. Preliminary hearing is a probable cause determination, but witnesses are called, evidence is presented. You'll find the strengths and weaknesses of the case from the prosecution standpoint, from the defense standpoint. A lot of times, after that, negotiations happen sometimes during the hearing or very shortly after. A lot of times after the hearing, once you have additional information about the actual facts of the case rather than just a written arrest report, there's bail modifications that come from that, either a release or reduction of bail or sometimes even an increase. Sometimes there's additional charges that occur out of that. So I realize the importance of a preliminary hearing, all the evidence to be presented at a preliminary hearing. For that reason, I was opposed to it. I would, to answer the last part of your question, I'm opposed to it in the future. As it passed, it really only applies to a limited scope. It's abuse of children, sexual offenses against the children, or serious domestic violence offenses, felony domestic violence offenses involving substantial bodily harm. However, as judges, we remain neutral on policy decisions. Policy decisions are up to the legislature. We did use the word neutral in conveying our thoughts to the legislature, but we still did voice our concerns in opposition to them. So I think there was some concern about the use of the word neutral, but those are my feelings about the 81.
Thank you, Your Honor.
Robert?
Judge, talking about policy decisions on the bench, what was
Looks like this is Craig Mueller, because he just showed up. He didn't announce your name.
fellow panelists? My name is Craig Miller. I appear in Justice Court without a microphone. That's the without a microphone. Justice Court bench. Test. All right, much better. The Justice Court bench unilaterally tripled and quadrupled bails settings for standard bail here in this last term. The consequences apparently were the jail is now at 110% of capacity. The Metropolitan Police Department instituted a policy of not arresting people without a sergeant's permission because they had to ration their jail space. What was the rationale for that policy shift? And were you in favor of it?
I don't believe we tripled the bail. We did modify the bail schedule, and there was a lot of reasons to modify the bail schedule. It was arbitrary, there were inconsistencies, there were errors in our bail schedule. We got to a point where whenever a new crime was enacted by the legislature, a judge, whoever was the chief at the time, would make a decision to apply a bail amount to that. Unfortunately, this happened in the past, if somebody, a division of Metro thought that there were serious crimes occurring, say vice offenses, they would come in and ask us to raise bail amounts on all vice offenses, prostitution-related offenses. So our bail schedule actually reduced bail in certain amounts, and it did certainly for those prostitution-related offenses. The new bail schedule reduced those amounts. It also reduced bail amounts on felony offenses. It did reduce possession of a controlled substance with intent to sell is one example. We substantially reduced bail there. Bail was increased on some other, but what the bail schedule did was really just simplify it, and it ties it into only the category of the offense. Now that was some years ago. I believe that was in 2011. Whether that gave rise to the increase in population at the jail, I think that has been debunked, because in fact last year, in response to some of the population concerns at the jail, we decreased every bail amount, and after several months, the numbers did not change whatsoever. There's other reasons that the population at the jail increased. There's house arrest concerns, there's district court concerns, there's a lot of other factors that went into the increase in population. The bails, and also, Judge Yeager talked about this a little bit, so I won't go into so many details. I know we're 3 candidates here, I want to give everybody enough time. But I am also on that committee, the statewide committee, the Nevada Judicial Council committee to study evidence-based pretrial release. I think that is going to, and we're in the beginning stages of that, but we're going to start testing very soon here. We're going to start a pilot project. That is going to change bail schedules also. I'm on a subcommittee to study bail schedules across the state, and I disagree how the current system, that bail schedules, the bail amounts are only tied to the nature of the offense, the potential penalty. That we have to make sure that we're considering all the statutory factors, ties to the community, danger to the community, employment, residence, character. There's more than just the financial ability to pay. We also have to consider the financial ability to pay. I can go over so many examples of one person being able to post bond, another one not being able to, and have the same exact offense. And this committee and what we're going forward, we're going to change a lot of processes, and the bail schedule will be addressed as part of that.
Okay, do you want to answer the members?
Steve, what do you think is the most important issue facing the Justice Court this next term?
Well, I think that the whole judicial process should be geared towards fairness towards the defendant, fairness towards all the parties or the counsel, and an overall sense of feeling that a defendant got their day in court. That's what I think would be the best thing for any sitting justice to do, to have everybody listen to all the sides and not turn a deaf ear and keep an open mind. Maybe it's a product of my defense background, but that's the way I feel.
Mr. Kurth, why don't you answer the same question?
I think that with what we've been seeing with the incumbency and the general distrust of the public recently, I think we need to make sure, even reading the paper today, I had a little break and I grabbed the paper and I picked it up, and not whether the allegations are true or not, but there's allegations of bias or prejudice and judicial conduct allegations alleged against 2 justices in North Las Vegas Municipal Court. And I think we need to do whatever we can to restore the integrity that we have in our system, so that everyone believes that's coming there, that they're getting a fair shot, whether or not they're represented by the public defender, or whether or not they're represented by a private counsel. counsel.
To Mr. Kurth and to Mr. Goldstein, you both identified deaf ears and people not getting a fair shake. Do you have specifics? Because I don't see that type of attitude in the general public outside a few newspaper articles.
Well, I'll go first, I guess. I'm in the courts every day, day in, day out. I see what goes on. I see that the cards are definitely stacked against the defendants in most situations. The DAs are trying to take a high bustling position on defense counsel, whether they're public defenders who are very much overworked and have high dockets themselves, high cases, or whether it's private counsel. I see it every day. I don't have one example that I could tell you, but I was at one of these functions just the other day where I was talking to one of the candidates who remained nameless. But that candidate said, well, I've only given 3 not guilties in my career. I found that to be abhorrent. I found that to be shocking. I mean, how does somebody find everybody guilty on that consistent level? So I don't have an exact number or exact case to cite with you, but it's very apparent across the board that defendants aren't getting a fair shake.
Yes, Brian. I think on a couple of different, let me see, I won't say venues, but in meeting with some of the members of the community, for instance, what we know about the Black Lives Movement, for instance, and how there's many people that have the perception that there's discrimination or bias or prejudice based on people's economic standing or their race, their ethnicity, and when they go through the system, they definitely feel that way. And whether or not it's this, it's this, I can't think of what they call it now, but, like a train to prison, a system that's just going there. I think a lot of people get in there, and these defendants, and they don't really understand all their rights. They don't get that much time with the public defender, and I think the Justice of the Peace needs to make sure, too, that they understand their rights and what they're doing, because they'll just take these pleas to something that's much more serious consequences, even immigration, that they don't understand that's going to affect their lives substantially in the future, whereas if they came to me later and they had private counsel and I was representing them, they're going to have something totally different. They're going to understand their rights, but and I think, part of it is, I think, the court process, because they have to take these pleas, they have to push these defendants through, because they just don't have enough time with the caseload that they have to get through everything. If everybody went in, like the defense attorneys before said, well, this is unfair, why are we getting all these warrant fees, why are we getting these negotiations on these traffic cases even, let's make them all go to trial. But the courts can never handle it in that situation.
I want to make sure you've indicated that there's a perception that there's unfairness, or that a Justice Court judge is only given 3 not guilty. Certainly most cases plea out, correct? And can you change perception without adversely affecting the rule of law?
I think you can change sure. I think you can do it if you come into the court and you're courteous to them, and they feel like you've listened to their case, you've given them their time, they've had their representation, they've had their day in court, they're not just going through a preliminary hearing that's rubber stamped. Oh, okay, well, we're just gonna, find over on every single charge and it's probable cause, and let's just do it. Like, you're not really, are you intent on listening to them, giving their day in court? I think once they feel that they've had that, then it will change it.
Nathan Atkins. This is for Judge Goldstein and Judge Kurth. you're both running against Judge Bonaventure. Clearly you believe that you can do the job better. Why do you think you can do the job better? And more specifically, what are you going to do different?
That's a very valid question. I think that what I can do better is, honestly, is listen to the defense, the defendants, the defense counsel, and keep an open mind and try to rectify everything with the facts of the case and the position of law. Okay, I think I can do that better. I have practiced for 18 years with very much a good success rate and an open mind. Like to mirror what Mr. Kurth was saying, is to just basically give everybody their day in court. Okay, and I don't think that that's been done that well thus far. Thank you.
You know, I think that I'll be courteous. I'm going to be courteous to the attorneys that come to my court. And I'm going to be courteous to those that appear before my court. And they're going to feel that I'm just not somebody that has some robe on, and I'm above and beyond them in their scope. Although they'll have to understand, obviously, you know, where the authority is. But being courteous, I think, is very important. And being able to make sure everyone feels and has had their day in court, and has had an opportunity to express their positions and that they're heard. You can't let them go on, and I know that Judge Bonaventure, you know, he does a good job. I'm not going to say that he doesn't do a good job. He does a good job. But my experience, I will tell you, is 24 years. 24 years practicing law in the civil and the criminal background. I represent these people and I know what they go through. I know how difficult it is for them with their finances. I know, you know, the people that are guilty that you represent. I know how it all has an influx and how it all meets with the other different courts and how it affects them and their families. And I think taking that experience and taking the law that I've learned and appearing in the Nevada Supreme Court, appearing in the Utah Supreme Court, the Utah Court of Appeals, those things, that I will be able to be a good jurist.
Thank you, Jim.
This question is specifically for Mr. Goldstein and Mr. Kurth. I hear both of you talk a lot about, well, I'll be fair. I don't think things are fair enough. We got to be more sensitive. Where my concern lies is, what about the fairness and the sensitivity to victims? Because I'm not hearing a whole lot of that out of either one of you. I understand that I want everybody to feel like they had their day in court and they had a fair process. But it seems to me that, like, if either one of you were elected, it's more about fairness than the rule of law. Could both of you respond to that, starting with Mr. Kurth, please?
Fairness? No, of course it's the rule of law. You have to, I mean, if somebody did something wrong and they violated it and it's there, then they need to be punished. But, you know, there's different ranges of punishment, for instance. You know, are you going to go 6 months in jail? Are you going to max out their fine? Are you going to put them on probation? Or are you going to, I mean, what are you going to make them do or not do? What kind of counseling? And, I mean, a lot of them need that. They need these extra services. And the victims need those services too. They've been through a lot. Everybody has, you know, there's different levels of victims. There's different levels of perception and how this has impacted their lives. I would ensure that they definitely feel that, you know, they've had their day too, that if they need to present something, to make sure that they can see that the system is working. Because sometimes the victims feel, or alleged victims, that they're not getting their time because they see all these plea negotiations and everything going on because the court has to work that way. And if there's some way that we can explain that process a little bit better to them, that the person is being punished, and that can help them emotionally, I think that would be a good thing also.
victims are first and foremost in the front of my mind when you consider these whole ordeals that they're going through. I have to consider all what they've gone through and temper that with the rule of law. If something really did happen, okay, if somebody is actually guilty, well, of course, you know, the victim is first and foremost the top of the list, the one I care about the most, and I would make sure that the person that was found guilty would listen to the victim, and I would rule as a judge accordingly and swiftly.
Judge Bonaventure, you have another question to ask you. In a few minutes, you can respond to the same question even though it's not directed at you.
You know, as a judge, I presided over every type of case in the Las Vegas Justice Court: civil, criminal, protection orders, extraditions, coroner's inquests. But you know, I of course wouldn't have direct contact, direct communication with a victim. However, a lot of times victims want to be heard. I would hope that, like say, the victim witness unit of the district attorney's office would facilitate them being allowed to be heard. There's certain procedures, there's certain court procedures that need to be followed. However, I do have instructions from my bailiff, my in-court bailiff, to check in anybody that's in the courtroom. Just if they're there, they want to be heard, then you know my bailiff is to notify the appropriate people, but most likely the district attorney. And it's just the opportunity to be heard, fairness to everybody, a judge to be fair, impartial, give everyone a notice to be heard, and still you know, apply the rule. That's how I answer.
I am Tip Patar. I'm a Veterans Party of America treasurer for the state of Nevada. So full disclosure, I was interviewed with Veterans of Politics the same day as Robert Kurth. So I talked about 10 words with the guy, but yeah, just want to let you guys know I am impartial. So with that being said, here's my question for you guys. Yeah. All right, here's my question for you guys. So, given the different challenges you guys have experienced in the court system, what would you feel that you're bringing to the table as far as your past experiences to help you basically overcome obstacles and hurdles in your job as a judge? Because you've all kind of highlighted different aspects of different types of courtrooms and cases and whatnot. But what do you think really gives you an edge, and so to speak, in your future dealings as judge if you were elected?
Who would you like to answer for that?
Well, everybody, we'll start with you, Judge.
All right, thank you. I like I said in the last question, I presided over every type of case in the Las Vegas Justice Court. Civil cases ranging from small claims, summary evictions, all the way to jury trials, actual jury trials in Justice Court for civil cases. Criminal cases from traffic violations and animal control violations to murder cases, serious preliminary hearings, high-profile cases here in town, extraditions, temporary protection orders, coroner's inquest. Every type of case in Justice Court I presided over. I started with a split civil criminal caseload. I moved to a strictly criminal caseload. I had an all DUI caseload for a time. But currently I'm the chief judge. I served as vice chief before that. I've been chief judge for over a year now. And there's different challenges associated with that. I'm not in court every morning. I'm in court less. I'm in court once a week, at least once a week. But I have now administrative duties to attend to. Going forward, I strongly have advocated for specialty court programs. I know there's been some mention in previous candidate questions about the Justice Court Veterans Court program. I actually assigned Judge Saragosa to preside over that. She volunteered for that, and I work closely with that court. I preside over a specialty court myself, a DUI specialty court. We also have a drug court. I would like to expand those types of opportunities, and so I think that's important.
Well, I feel that my overall life experiences are proof positive that I would be a very fair jurist. I've been, like I said at the very beginning, I've been a arbitrator. Those are cases that are civil cases. that have a value that are under $50,000. And I've had arbitrations, I've done countless numbers of those. I've done every aspect of civil litigation, which there is civil litigation departments here in justice court. So I've done that. I've done trials, numerous trials, whether they be civil or criminal. I have had, I've also served as a small claims referee for a number of years. I also served as a traffic hearing master, or a, I guess you would call it a pro tem judge down, and I've done a lot of traffic disputes, all of which I bring to the table 18 years experience of being level-headed, calm, and definitely think that I can get into the system and assess it, make it better.
If I recall the question, but I'm in my 24th year practicing law. Since 1996, I've been managing my own law practice. Just like you would have to manage your own, manage everybody that works for you in the justice court. It's just of the peace. I was an arbitrator for 13, 14 years here. I sat as a small claims referee. I sat as an alternate child support hearing master. Heard those cases, held people in contempt, made those decisions. Most of all, I would say that I've been in the courtrooms, and I've been into the justice court, I run a municipal court, I run the district court, and I've handled major cases that have impacted cities in the state of Nevada, down to what we do in justice court. And I remember when I first started out, I had a preliminary hearing with, there's like 9 attorneys in there, attempted murder charges and things like that, just when I was a new attorney. It's, I think, taking those experiences, taking those, dealing with the people, dealing with the victims, knowing what they've gone through, knowing what it's like to, deal with that. Overall, with the demeanor that I have, and with my integrity, that I believe that I would do a very good job.
Thank you all.
Hi, my name is Ron Q. Keelang, business owner in town. Due to my involvement with Robert Kurth as my legal counsel and also my private attorney, I would recusing myself to vote in this panel and also ask any question. However, he has my 100%, my company supporting his campaign 100%. Thank you.
Hi, my name is Michael Broadway. Judge Bonaventure, Monty says you're the best. That's quite the highest regards there. I appreciate your being here, not being strong-armed by special interest groups. My questions, though, are going to go to the other 2 guys, Mr. Goldstein, Mr. Kurth. With everybody liking Judge Bonaventure as it is, what do you think you can do better?
Well, I think that, I'm sorry, I'll go first. I think I don't know what more we can say, but I'll say this thing. I think that judicial evaluations are difficult, but it's something that we rely on. I think that I don't understand why judges' evaluations are not in the 80s. I don't understand that. I mean, in Henderson, you see very good evaluations, but, and I think Judge Bonaventure is about in the middle of the justices of the peace in their evaluations right now. So for some reason, if somebody's working for me, or or if I'm working for somebody else and they're going to grade me and give me an evaluation, and my evaluation is 71, I would feel that is satisfactory. And I know there's a lot of things that go into that. Everybody doesn't participate in them. They're difficult. What I can tell you is that I would strive to do my best to get my evaluations in those 80s. And I would hope they would be. And there are some judges that are. And I think that would happen because you would elect someone that's going to listen to the concerns that are being presented, that's going to respect people's rights. that's going to enforce the Constitution, enforce the rule of law, that's going to protect our families. And that's what I would do.
I respect Judge Bonaventure. He's a very fine jurist. I just think that I can do better with the things that I want to make sure are properly dealt with in the judicial forum. Civility, courtesy, hearing everybody out, making sure everybody has their day in court. Those are very much the top of the list. And like Mr. Kurth has said, if a jurist does that, then there should be no problem with somebody being rated in the 80s, even in the 90s. It can be done. Thank you.
Thank you, guys.
And Jason, if you can ask the last questions, because we're right at the cutoff time, and go ahead.
Okay. Jason Stoffel. This question is for Mr. Kurth. Mr. Kurth, I've noted that you've run for judge 4 other times, 2010, 11, 12, and 2014. And now in 2014, you received 45% of the vote against family court judge. The question is, why do you believe you'll be elected in 2016, and are you electable?
Well, I think so. I think there's a lot of things. I mean, there's several people that run for election that haven't made it. I mean, I tried to look at Abraham Lincoln. He ran several times. I don't have it all written down, but he finally did win and won the presidency. And he didn't give up. I think perseverance is important. You know, judicial races a lot are about name recognition, getting the vote out. Last time around, we're going to have a little bit more people voting. More people are engaged. I think a lot of people are engaged this time around as far as there's a lot of anti-incumbency sentiment, I think. And I believe that I built on my name recognition, built it up, which I think is important in the Justice Court race. And I have a lot of supporters. I have a lot of people that have voted for me in the past, and that I believe will vote for me this time and get me over the hump.
Actually, that quick answer, I think we can squeeze in one more.
There's only 2 of us left, so we might as well.
All right. You hear that, Steve? It's not my choice.
You're the moderator.
Doesn't matter. I'm part of the people.
Listening to all of you, more specifically the challengers, I have really serious concerns about your ability to be impartial and not be swayed by your background and interests. I noted that you do appear to have a pro-defense bias, mainly probably because of your background. However, when talking about a defendant's rights and not highlighting the rights of a victim who has no choice in who their attorney is, and really has the worst, most overburdened attorney because they're represented by the state, I have concerns that your background would prevent you from making sure that they have their day in court. You indicated, of course, if the facts decided that a victim had been, in fact, a victim of a crime. It's not really your place to decide the facts. I view that as a function of a jury. So how can you tell me that I'm wrong in perceiving your pro-defense bias?
Well, I'll handle this as best as I can. It's a very valid question. Right now, in the justice court system, there are no juries that are allowed. Now, if my boss has anything to do with that, he's got cases and he's done motions to try to get juries instated in justice court, according to the Constitution of the state of Nevada. That's an inviolate right. So he's fighting. But the reality is, right now, the judge is the jury and the final arbitrator of these facts. So, you know, we would listen to the victim when they were testifying. We would listen to them, keep an open mind, and then rule accordingly with the law. The rule of law is very important. I think the victim will most likely be vindicated if the facts bear out.
So how
how does that address cases where it's your decision whether to bind it over to district court? It seems like you're making a decision ahead of time that should be a function of the district court.
Well, the preliminary hearing stage is when they determine whether there's enough evidence to be bound up to district court, and that's where there is a jury component allowed. It is a minimal standard at that point. It's not a clear and convincing or beyond a reasonable doubt standard. It's whether there's enough facts. And if there aren't enough facts that bear out at that stage, then it is what it is, and we're going to rule on that. It's tough. I understand that. But if the prosecution hasn't put forth the case, then that's what the judge at that stage is for, is to make sure that there are only proper things that go up to the district court.
Ms. Thomas, first, my background is I'm a very conservative person. My son actually works for Metro. Be that as it may, I clerked in the district attorney's office back when I was in law school, a long time ago, back around 1990. And I thought about taking that route, and it just, they weren't hiring at that time, they were having a hiring freeze, for instance. So being on the other side as a defense attorney, that's what we do. I mean, we defend, make sure that everyone else is doing their jobs. Make sure the police are doing their jobs, make sure the prosecution is doing their jobs, present it before the court. If everybody's done that, then the judge is going to rule. The facts are the facts. In justice court, the judge is the determiner of the facts. Now, I do believe that, I thought that you could have a jury trial on a civil case. I've never had one in justice court, but I thought that the rules allow for that. I had a client I was representing that we were set to have one, and then we got it pushed out to district court, which is where it should have been, because it was a complex real estate matter. And I think that's somewhere where my experience helps too. But my background is, I'm a little more on the conservative side of it. One of my mantras is that I'll be tough on crime. But in being tough on crime, I think you also have to look at, you just have to, I'm telling you that I'll be fair and impartial. If somebody does the crime, yeah, they're going to do the time. But I don't think it's a rubber stamp process. And I think sometimes judges get on the bench, and after a while, they've heard the same story so many times. Well, sometimes the story is true. And sometimes the story might be about somebody that you know that wasn't in the system before, that you don't realize until it happens. And at this time, the boy you cried wolf, maybe there is the wolf. So I would be sensitive to that, because I've seen it and I've been through it. Thank you.
I'm sorry, we've been cut off. So this time I'd like to thank Judge Bonaventure, Mr. Goldstein, Mr. Kurth for your time in the middle of the afternoon. A round of applause.
Thank you.